Yep. So I'm sure there's thousands of people out there on YouTube that are just dying for this to start. Y'all are going to be stars. So there we go. All right. We're ready to go. It is defendant's motion. Yep. So I'm sure there's thousands of people out there on YouTube that are just dying for this to start. Hold on. Hold on. Oh, there we go. All right, we're ready to go. It is, hold on, defendant's motion. Yeah, so I'm sure there's thousands of people out there. There we go. There's a delay between this and YouTube. That was the YouTube playing. All right, Ms. Talley, are you ready?
I am, Your Honor. Okay. Your Honor, would you like a recitation of the facts?
I don't think I'm aware.
Okay. Your Honor, may it please the court, this is defendant's motion for summary judgment in the Dante Rawlins versus Fitness International. It's defendant's position today that summary judgment is appropriate for several reasons. For the first reason being that at the time, Mr. Rawlins has repeatedly denied signing the guest pass waiver on the day of the incident. And so at that point, defendant believes that Mr. Rawlins' presence on the property can be considered that of a trespasser. And as I'm sure you're aware, a trespasser is one who, though peacefully or by mistake, wrongfully enters upon property owned or occupied by another. And that's listed in Barber v. Steele. And then once the trespasser's presence becomes known, the only duty of the owner is to refrain from willfully and wantonly injuring him. Like I said before, plaintiff has readily admitted that he was a trespasser at the time of the incident, through his employment with LA Fitness and his regular visits to the gym. He was aware that guests who were not with the policyholder were to wait on the policyholder. They weren't allowed to enter without that policyholder, and he knowingly did so on several occasions. And as stated, he signed up in his deposition, admitted to signing up several individuals with the guest pass waiver. So he was aware of that language. And so it's defendant's position that at that time of the incident, Mr. Rawlins was a trespasser. And then our duty was significantly reduced to him. We cited that the fact that failure to give warnings, instructions, or assistance doesn't amount to active negligence in Staten v. Griffin. In that case, they found that no active negligence when a premises owner allowed people to operate the zip line without any safety or equipment in addition to failing to warn of its danger. And Your Honor, in that case is distinguished because at that point, those individuals were invitees, which yields a higher duty. But unfortunately, that's not the same here. And so if the court could find that it was not the defendant's responsibility to warn of negligence with something as dangerous as a zip line to invitees, then certainly the court could not find that defendant Fitness International had a duty to Mr. Rawlins as a trespasser. And then if Mr. Rawlins wanted to contend that there is active negligence here in the case at bar, the incident with Mr. Berlin was absolutely not foreseeable. We cited to Custer v. Coward there, where the court granted summary judgment after a dog bit a neighbor invitee, after determining that, the few occasions that the dog growled in the past does not speak to the dog's propensity to bite. And so we know here that plaintiffs have cited to former employee, Mr. Terrence Hutchins, to speak to Mr. Berlin's propensity for violence. He was known as overly physical and aggressive. And Your Honor, defendant's stance is that, even if that is true, nothing, the affidavit has not provided any specific incidents as to speak to the overly violent or overly physical and violent nature of Mr. Berlin. And so, it just follows that it was not, Mr. Berlin's attack was simply just not foreseeable for the defense. And then, Your Honor, it just follows that if, you are uncomfortable with classifying plaintiff as a trespasser at the time of the incident, for various reasons, then, it's defendant's position that the waiver in place, the guest pass waiver that he had signed, which he is stating was, several months, if not a year prior to the incident, it is defendant's position that that waiver is still bound and enforceable in this situation here. And so defendant cites to the seminal case here, which is Toner v. Just Fitness for You. Plaintiff there had a similar argument. She signed a kind of a waiver of liability previously, but the incident happened the next calendar year. And there the court just found that it was, simply just kind of unnecessary for a gym to ask its members to complete that guest waiver each and every time that the member exercised, as it would just kind of just be cumbersome and just not necessary to effectively complete the workout, but then have the necessary defenses in place, so to speak. And so similarly here, plaintiff is saying, well, that waiver was signed years prior or months prior, or I was younger, or that wasn't on the time of the incident. And it's just defendant's position that just doesn't really matter here. The court has already found, well, this lady, she's making the same argument. She signed it months prior to the incident. She was a regular member. So it's just kind of unreasonable that, we would allow these individuals to come in, use the facilities, at will, whenever, but then kind of skate by without the protections and parameters in place. That just is not something that was the court in Toner v. Just Fitness for You found to be fair. And so allowing plaintiff to conveniently escape the conditions to which he knowingly and voluntarily agreed to, either by signing the guest pass waiver whenever he did prior to the incident, or by, continuously frequenting the premises to play basketball or work out with his dad or what have you. It would just allow him to escape the conditions to which he agreed to, just because they aren't favorable for him in this moment. And as I mentioned before, plaintiff is very familiar with the policies here. He was an employee at LA Fitness, and in his deposition testimony, he readily admitted to signing multiple people up with the guest pass waiver. He admitted to knowing the contents of the guest waiver. He admitted to knowing that, he was not supposed to be there without the policyholder, which was his father. All of these things are familiar to the plaintiff. This is no surprise, and he still decided to enter in spite of. And so it's just defendant's position that he is not able to do kind of what he wants to do and decide that, the rules don't apply to him and, use it to his advantage. And then finally, Your Honor, since it follows that, the waiver is valid and enforceable, then it also follows that, there's no gross negligence here. In order to, I guess, upend the waiver and, litigate this case, then there has to be a finding of gross negligence. And, we defendants feel like that's probably most pertinent to the analysis here. There's just simply no evidence of gross negligence. Plaintiff's injuries are unfortunate. I believe he was 21 at the time of the incident. That's pivotal. That's a pivotal age as far as like young adulthood, and that is very unfortunate, but they do not amount to, the actions of defendant do not amount to gross negligence. The definition for gross negligence can't be more clear. The incident causing the injury must be substantially similar in type to the previous criminal activities occurring on or near the premises, so that a reasonable person would take ordinary precautions to protect his or her customers. Here, there is no evidence in the record or otherwise that Mr. Boleyn's actions on the day of the incident were substantially similar to anything that had occurred previously. Even in the affidavit supplied by plaintiff, the terms are vague. He says, oh, well, Mr. Boleyn had a reputation for, being notoriously overly physical and aggressive, but he still doesn't point to specific incidents that are substantially similar. And even in plaintiff's own words in the brief, his response brief, plaintiff says, well, this is a vicious attack. It was sudden, without warning. It came out of nowhere. And in plaintiff's deposition, he said, I played basketball 3 to 4 times a week, and I hadn't even heard of this guy. I don't know Mr. Boleyn. I had never heard of any altercations on the basketball court. He was a regular. And so, if plaintiff himself can't speak to substantially similar incidents, physical violence, plaintiff's had some pretty physical injuries, and he can't name any incident. And then, okay, well, plaintiff wants to say, well, Mr. Rawlins was only there 3 to 4 times a week, only a few hours at a time. There's no way that he would be aware. Well, then, why couldn't their former employees speak to specific instances involving Mr. Boleyn or otherwise? And so, unfortunately, plaintiff has only ventured into part of the analysis required for a finding of gross negligence. He's using that affidavit to provide evidence of Mr. Boleyn's propensity to violence. But, when we dig further into the specific instances or similar to the subject incident, plaintiff has simply failed to provide even a scintilla of evidence. In his own words, this attack was violent, it was gruesome, it was sudden. There's just simply no evidence of anything similar here, either on the basketball court or even in the gym or in the pool or the surrounding areas with Mr. Boleyn or otherwise. And so that's just the defendant's position. And additionally, Your Honor, not only were Mr. Boleyn's actions not foreseeable, but it's also defendant's position that Mr. Rawlins, plaintiff here, engaged in mutual combat. So in plaintiff's deposition, he admitted to confronting Mr. Boleyn. Though they were on the same team, he admitted to going to Mr. Boleyn and saying, hey, you don't have to file, or whatever was said. He admitted to, being the catalyst to that attack. And then after the two had been separated, plaintiff took it upon himself to throw a basketball. And, plaintiff attempts to kind of diffuse the importance of that by saying, well, I just threw it in his general direction. I didn't throw it at him. If I wanted to hit him, I could have hit him. Well, Your Honor, those are antagonistic actions. You've been separated. This guy is clearly angry. In your words, he's unstable, he's unpredictable. And yet you choose to throw a basketball in his direction, further provoking him. At that point, it's defendant's stance that that's sending a clear message that you're willing to continue to engage in this activity. At this point, it's by your definition, it has left an attack. Now you're engaging in the combat and you're welcoming any response from him. And so at that point, defendant believes that the mutual combatant rule comes into play. And so for those reasons, mainly for the waiver and the fact that, it would be kind of unfair and unjust to allow plaintiff to kind of use the rules as they work for him, but not abide by them as required. It's the defendant's position that that's unfair, and the courts have already found and established that signing a guest pass waiver, previously prior to the incident does not negate the effectiveness of that waiver. And because the waiver here is in place, then, the only question here, the only question left to follow is left to decide is whether or not there has been gross negligence. And there's simply just no evidence of any substantially similar attacks here that would support a finding of gross negligence. And so for those reasons, defendant respectfully requests that its motion for summary judgment be granted here.
Thank you, ma'am. Mr. Mickelson?
Yes, thank you, Your Honor. May it please the court. Before I dive into a few of the facts, because I think it's important that we hone in on some of those, from our perspective at least, the record hasn't been represented accurately. But I want to remind the court and opposing counsel of the legal standard very briefly for a summary judgment case, such as this one in Georgia. When a court in Georgia considers a summary judgment motion, as this court knows, it must view all pleadings and evidence in the light most favorable to the non-moving party, which would be Mr. Rawlins here. Further, the court's required to accept the credibility of all evidence that Mr. Rawlins relies on and afford that evidence as much weight as reasonably can bear. And to the extent that the defendants in this case point to conflicting evidence, to discredit that evidence for purposes of the motion. So It's a very high bar that the defendants have to reach in order to overcome a summary judgment. And all Mr. Rawlins has to show is that there's slight evidence to create a genuine issue of material fact. There are a number of factual disputes in this case, Your Honor, and that's why I wanted to review this very briefly. Mr. Rawlins, was not employed by LA Fitness at the time and had not been employed at that LA Fitness for some time. He goes to LA Fitness that night to play basketball. He's going to meet his dad there. When he arrives, an employee he knew by the name of Cassandra Kerrigan gave him express permission to use the facility and waved him through. She had done this in the past. Others had done this in the past. That's his testimony. He did not sign a liability waiver or an assumption of risk form. He did not sign anything. He did not pay the $15 for the guest pass. He didn't have his picture taken. He went to the gym and he started playing basketball. Now, the way these games work, because I've played some of them before, is people just kind of pick up games and you're assigned to a team. So one of his teammates was Antonio Belen. Didn't know the guy, never met him before. Mr. Belen began fouling very hard and playing overly physical and aggressive during the game. Mr. Rawlins politely asked Mr. Belen to take it easy. What follows is largely captured on defendant's own video footage. Mr. Belen attacks Mr. Rawlins and chases him around the gym, punching him several times and shattering Mr. Rawlins' jaw. There's no evidence from the video footage that Mr. Rawlins provoked Mr. Belen. There's no evidence that Mr. Rawlins hit him back. He was running from him, literally around the gym. Mr. Belen after Mr. Belen had shattered Mr. Rawlins' jaw, Belen left. Rawlins went into the locker room, not knowing where Belen was, at which time he threw the basketball in the general direction of Belen. Belen then attacked Mr. Rawlins for the second time. There's no evidence that Rawlins hit, assaulted, or attacked Belen. No evidence of mutual combat. And to the extent that there is, that's an entirely separate incident from the first incident where he shattered his jaw. At least 2 employees who were present on the night in question knew Belen prior to the subject incident. In their affidavits and in deposition testimony, they knew he was a trespasser. They knew he had been in physical fights before. They knew he was an instigator and a troublemaker, and they knew that he was overly physical and aggressive. Nevertheless, Belen was never trespassed from the facility. Nothing was done to address him and his dangerous behaviors. No one even investigated into his status as a guest or a member as a trespasser. There are several genuine issues of material fact, including whether Mr. Rawlins signed anything on the night in question, whether he had the signature that they claim is his that looks nothing like his, whether he had his photo taken. Well, if you look at the video, he's wearing something entirely different from what the video shows. And according to their corporate deposition testimony, the photograph would have captured his appearance in the day in question.
Well, they're not saying the photo was from that day, right?
What was that?
I mean, they're not saying the photo was from that day, right?
They are saying that the photo was from that day, because the testimony is that when you go in each time and have your photo taken, it automatically populates back into the system that photo from that day. That was the testimony from the 30B6 witness. So whether there's another question as to whether the defendants knew Mr. Belen was the trespasser, even though their employees knew that he was, or whether defendants knew that he had been in fights at LA Fitness before. Again, we have an affidavit from an employee of theirs who says that he was aware of him getting in physical altercations. So when we construe all this evidence in favor of Mr. Rawlins and accept the credibility of all this evidence on which he relies and discredits whatever defendants are proffering, our contention is this is a case ripe for a jury. So I want to address a few points that opposing counsel made. The first is that Rawlins was a trespasser. Okay, this argument disregards prior testimony and frankly makes no sense. First, defendants argue that Mr. Rawlins was allowed to enter the premises as a member's guest with guest privileges. Okay, then defendants contend that because Mr. Rawlins' father, the member, was not present, Mr. Rawlins had to pay $15 for the guest pass. Both scenarios would make Mr. Rawlins an invitee. Then, when defendants could not produce the receipt of the $15, which they promised to do during discovery, they changed their story entirely, and they now argue that Mr. Rawlins actually never paid $15, but that he was a guest of an Albert Hansborough who he has never heard of and has never met, and who appears to be dead. According to defendants, because Mr. Rawlins had never been a guest of Albert Hansborough, he took a new photograph and signed a new waiver on March 28, 2018. The basis for this new argument is an affidavit signed by a corporate employee never disclosed during discovery, and the speculation that because Mr. Rawlins supposedly arrived around the same times as this Mr. Hansborough man, Mr. Rawlins must have been his guest. Since that argument does not work, defendants for the first time in their reply brief claim that Mr. Rawlins is now a trespasser when he was expressly given permission by their own employees to go in. He didn't know whether his dad was there or not there. He was going to meet his dad. He had done that before, and they had done it for other people too, and that's the testimony that there's been in this record. So despite defendants throw everything against the wall and see what sticks strategy, Rawlins has remained consistent about what happened that night. Never signed the waiver, never paid the $15, never had a photo taken of him. He recognized the front desk woman. She gave him express permission. He was an invited guest. The defense knew he was there. They consented to it. They waved him through. They welcomed him there. The Stanton opinion that they cite in their brief concerns an injury from a zip line. We're not talking about that. We're talking about third-party criminal attacks. So as this court knows, and as the defendants know, a business has a duty to protect invitees from dangers, including third-party criminal attacks, and to warn against them. I cite to OCGA 51-3-1 and Matt versus Days Inn of America Incorporated, 212 Georgia Appeals 792, 1994. Defendants also cite to the Custer case, which concerns an injury from the dog bite. Again, not relevant here. The substantially similar standard doesn't mean that it has to be identical. That refers to prior crime. This is not a prior crime case. This is the dangerous condition is Mr. Boleyn himself. They had knowledge of the dangerous condition. They knew about his propensities to get in fights and to engage in violent and physical and aggressive behavior. They knew he was a trespasser, and they didn't remove him from the premises. In their own 30B6 deposition, they said that had they known that, or their employees known that, he would have never been let in, and that allowing him to be on the property would be reckless, even a standard higher than gross negligence. Okay, so the next thing that I want to look at very quickly is defendant's argument that waivers do not have an expiration date. That's not consistent with Georgia law and against public policy. Okay, and it's against public policy. Rawlins did not sign anything on the night in question, and the last documents that the defendants believe to be signed by Rawlins is nearly 2 years removed. Okay, Rawlins was never asked about these documents in his deposition because the defendants did not produce them during discovery, even though we repeatedly asked for them. Rawlins has no memory of signing these documents. Okay, plaintiff cites Siebers versus Dixie Speedway. That is a third-party criminal attack case. The Court of Appeals reversed the trial court's granting of a motion for summary judgment. There, the plaintiff had signed liability waivers on other dates, but didn't sign one on the date in question, and that justified the denial of summary judgment. Interestingly, the defendants never addressed this case in their brief or cited to any appellate opinion in support of their position. The only thing they cite to is the Toner order, which is a trial court order, and that's persuasive and not binding. Defendants ask this court to hold as a matter of law that if one signs a liability waiver 2 years before they are injured, or 5 years, or 10 years, that waiver of liability must apply. That's not Georgia law, and that's not the legislator's intent. Unlike Mr. Rawlins, who cites to a Court of Appeals opinion, they cited to a trial court order that does not address waivers of liability in the context of third-party criminal attacks. That order is Toner versus Just Fitness. In Toner, the plaintiff was injured when someone using a nearby barbell removed weights from one side, causing the bar to be imbalanced, and then it catapulted the bar and it struck the plaintiff. So the case is about misusing exercise equipment and the negligent placement of that equipment. In Toner, the injured party was a member, not a guest, and had signed a membership agreement, which had a liability waiver in it a few months before the subject incident. The liability waiver contemplated injury from use of equipment and facility, like the waiver at issue here. It didn't contemplate third-party criminal attacks. All the cases defendants cite to in their briefing refer to injury from defective equipment or slip and falls due to spilled Gatorade. If you contrast Toner, Rawlins, as he never signed anything, even assuming that he did, though, it would have been at least 2 years prior to the date in question. Rawlins was not a member. Rawlins was not injured by exercising or using or misusing equipment. He was assaulted by a known trespasser. There's no evidence in the record that Mr. Rawlins contemplated waiving his right to third-party criminal attacks. I'll also add that Toner does not address the allegations of gross negligence or violations of public policy that are at play here in this case. In Toner, there was no evidence of superior knowledge of a dangerous condition. Here there is. Boleyn was a known danger for violence, fighting, instigating conflict, yet no steps were taken to remove him from the premises. The last point I want to get across, Your Honor, is this argument of gross negligence. And I want to be clear about something right out of the get-go. I want to be clear about what the defendants and their employees actually knew before the incident. So the defendant suggests this court that they only knew that Mr. Boleyn had a reputation for being physical or aggressive. And that's not accurate. The affidavit of the employee who was there on the night in question says, quote, before March 2018, Mr. Boleyn was a known problem at the LA Fitness. He was an instigator. He was known to get into fights and arguments. He was overly physical and aggressive. To my knowledge, he was not a member or a registered guest. Before the night in question, Mr. Boleyn was a known trespasser and known to get into fights and arguments and was known to be physically overly aggressive, and he was an instigator. Ms. Kerrigan, an employee, likewise knew Boleyn was a troublemaker and that he had been in fights before. They cite a Shadow versus FedEx case. This concerns a mass shooting at a FedEx facility in Kennesaw that resulted in an employee's death. There, the Court of Appeals held that a mass shooting was not foreseeable because there had never been a shooting.
You don't need to review that.
Okay, got it. Okay, so this is what I want to say, though. She quoted a portion of the Shadow opinion that somehow connects gross negligence to what's substantially similar. That's actually not accurate. I looked at the case, read through it multiple times. Nowhere in that case does it even mention gross negligence. I think the substantially similar goes to prior crime and the issues of foreseeability. Gross negligence, and defendants agree, is defined as, quote, the want of slight care and diligence, and such care as careless and attentive persons would usually exercise under the circumstances. And then the law also says that where there is room for a difference of opinion between reasonable people, whether there is gross negligence, that it's reserved for the exclusive province of the jury. Okay, as this court knows, the 30B6 witness testified that their knowledge of Boleyn, had they had it, which they did, we found out, was reckless, a higher standard than gross negligence. So certainly there is slight evidence of gross negligence here. Certainly there's enough evidence here that reasonable minds can disagree on whether there is gross negligence.
All right, counsel, I'll have to ask you to wrap it up. I'm sorry.
Yeah, no, I appreciate your time, Your Honor. Those are the main arguments that we have. Our position, obviously, is that this court should deny the motion for summary judgment as there are multiple issues of genuine issues of material fact, and we thank you for your time.
Thank you. Ms. Talley, do you have anything briefly in response?
I do have things briefly, really quick.
I've got like 5 minutes. I have a meeting that I have to attend. I'm sorry. So
No, I understand. Just really briefly, plaintiff's counsel cites to the affidavit of Terrence Hutchins. And, while this affidavit does say, well, he was a known problem, he was an instigator, he was known to get in fights and arguments, Your Honor, it's our position that those are such vague statements. It doesn't say anything about those fights. It doesn't say anything as to the circumstances surrounding those fights. And it just doesn't speak to the incident that happened here as far as, okay, yes, like this man was known to suddenly attack people without warning. These are just vague attempts to link the two behaviors together. And it's the defendant's position that, the gross negligence standard requires for there to be something substantially similar, and simply is defendant's stance that plaintiff can't point to any substantially similar behaviors of Mr. Boleyn.
Okay. Thank y'all both. The facts are all over the place in this case. And at any time that's the situation, y'all know what the court's going to do. I mean, I think I'm compelled at this point to deny the motion for summary judgment. I mean, there's plenty of more steps in this case where, we can readdress some issues, but at this stage, I'm going to go ahead and deny the motion.
Okay.
Appreciate your time, Your
All
Honor.
right. Yep, absolutely. Thank y'all for appearing by Zoom, and thank you for being patient on getting it set up again.
Thank you.